invite this out.
Okay. I'm not logged in, so is anyone online?
I'm Caroline.
So this is the legal committee meeting, August 13th. August 13th. We'll begin with roll call. We have Jason present, and Jenny, and Claire, who is not late, and Margaret, so all present. This evening, Jack Hornicle is going to give us some information on Mill Street. These are documents that were submitted to the full council at our last meeting. We did not discuss them at that meeting. So Jack is going to go over, I guess you're going to go over the parkland piece first, and then you had submitted 2 resolutions for consideration. Correct?
Sure.
Okay. So if you wouldn't mind being close to the mic.
Yeah. Thanks for.
You want me to pull it up?
Yeah, pull it up on the screen.
Sure.
The public comment?
Begin with
Parkland stuff?
begin with the one that says
The email is the email that I sent with the.
parkland status.
That's probably the resolution.
Parkland status of Mill Street.
Oh, that's the stuff from last.
This is yes, this is something that you had sent to us last year, and it has all of the history of Parkland. I don't know if you want to give us a summary, just a quick overview of, because this is the basis of one of your resolutions.
Yeah, that's right. So I don't have a great speech prepared today. I really figured this would be a conversation. So the information that I submitted to council last year, that I sent again a month ago, is a body of research that I conducted. It's a combination of mostly municipal plans that are on record available on the City of Hudson website, and the deed for the property, which is still the record of ownership currently under the city's ownership, that contains the parkland dedication clause. It's in writing from the school district. That's from June of 1983. And then there's some photos and stuff in the email too. But really, I guess the law on parkland alienation is that when a municipality owns land that it uses and puts forward to the public as parkland, that is either expressly in writing dedicated or impliedly dedicated through its actions, that land is subject to an extra layer of protection, and any sale or use other than parkland has to be approved by the New York State Legislature. It's not an uncommon thing for the legislature to do. They do 5 to 10 a year, and you can find them. The last one I found was in Kinderhook from a year or 2 ago for creating a fire department building or something like that. It's just a matter of course. It was not done here for this project. I think the record really thoroughly shows that the land for 100 years has been used as a public park. It began as the ball yard, the playground basically for the Charles Williams School, which is up the hill. It's the same kind of relationship with JLE. The school is on the hill and then the playground is below. In the 70s, the city kicked up a softball team, and I went to the Columbia Green and looked at all these old Register Star articles and found this league was in operation throughout the summer from Memorial Day to Labor Day, Tuesday, Wednesday, Thursday games. They had a tournament mid-year, and this went on for 25, 30 years. And then since then, it's shown up in the municipal plans over and over again as being part of Charles Williams Park. I think the strongest evidence is that the city itself, when it applied for the funding to build the playground on the north side of the street, acknowledged that the south side of the street was already parkland, already being used as a baseball field. And so they were awarded money from the state to build that playground on the north side of the street on that basis. So that is another kind of written declaration. And then really just in the last 20 years, it still is used. It's used today. 2 nights ago, there were 10 kids playing soccer on the field. Today, there were 2 kids riding around on dirt bikes. They like to ride up the embankment. There was a man who every day went cross-country skiing on it when there was snow. It's still in the mind of the public. It's still mowed by the DPW on a weekly or monthly basis. So It's still effectively a piece of parkland that the city is in contract to sell, having not performed the final act of going through the New York State legislature.
So, Ken, by the way, can't be here tonight.
Okay.
So you presented us with,
Yeah, I guess
you sent us 2 resolutions. Do you want to walk us through those?
Yeah, I guess if you want me to finish the thought on the parkland
Yeah,
piece. There's a case called Gladsky v. Glen Cove that says anytime a city enters a contract to sell parkland that it doesn't, and the contract doesn't contemplate going through the state, and they don't go through the state, then the sale can't go forward and the contract is null and void. And that's clear in that case, Gladsky v. Glen Cove. So I think that deficiency alone is enough for the city to remove itself from this contract with Kearney. And the resolution that I drafted is really to resolve any ambiguity as to the status of the parkland, because there isn't the reason this is still an open question is because when I raised this a year ago, the answer from council at the time was there is no, there's no ribbon cutting, there is no official declaration that's in writing. But as I've said, it's been used this way for 100 years. It shows up in municipal plans over and over again. And really the body of law supports that conclusion. So I put that resolution together to make that clear once and for all that the status of the land is parkland, which doesn't mean that it can never be built. It just means it has to be built in coordination with the state government. They have to support the project too. So that's what the parkland resolution is there.
Any questions on that? Claire?
I was just thinking that just the fact that the city asked the school district to remove the clause also implies parkland. Like it's a confirmation, the act of asking for the clause to be removed.
Yeah, and so that clause says if the city ever doesn't use it as parkland, then it goes back to the school. So the city's acknowledging that it has been parkland up until this proposed transaction and wants the school to give them the green light. And like I said, it still is used as parkland this week. Still mown by the DPW, people still play out.
So what do we want to do with the parkland resolution?
That's trying to sort out which one.
It's, if you look at the document that's labeled Kearney Contract and Mill Street.
Just scroll down, yeah.
Public comment.
Okay.
Can you see that one? 7/16/26 adopted. There's a communication at the beginning and then 2 resolutions.
Yeah, so it's the second resolution.
There, it's the second resolution.
Yeah.
Did you have any questions? Mark?
No, I'm rereading and was listening, and yeah, I'm curious what the next steps are too. Is it for us to meet with Dee Dee Barrett on this?
I'm sorry?
Is it to meet with Dee Dee Barrett on this next and have the conversation and see what her experience has been with situations like this, or is it to bring it to the full council?
I think we should bring it to the full council because, any action that's going to happen has to happen in the council. So my suggestion is that we take this to the full council for their input. I have no question from what was presented last year, from what was summarized in this resolution, that this is parkland.
Speak up.
Sorry.
It's okay.
There's no question in my mind that this is parkland. And I think to Jason's point, that the city asked the school to remove that clause, and that it's in the deed, that it can be only used for recreation and so forth. I think there's a lot of documentation here that this is in fact parkland. And the process that you're describing, that state process was not followed. So I think probably taking it to full council, it's unfortunate that Common Council isn't here this evening, but I think we need to get input on that. and possibly also get input from Andy Hart. So I'm not really sure that talking to you is, I don't know that's our next step.
I actually do have a question, because I wasn't paying attention to this part of the conversation prior to being on council. So what was the previous administration's response to, like, the, acknowledgement of this being parkland? What was the rebuttal to that?
Of last year?
Meaning the mayor or the?
Yeah, the mayor who presented the project and or the developers, like did they have refuting
I don't
information?
remember.
Well, Jack,
Yeah,
any response?
The response I got when I presented the information to Common Council was that they disagreed because there was no formal declaration. No, I mean, you can imagine it, like,
There's no sign.
there's no sign on that side of the field. It still lacks improvements. There's nothing over there anymore. There were lights and a backstop.
But were they speaking from like a legal opinion?
No, not really.
No.
And also a case was made, which didn't make a lot of sense, that when we were applying for grants for the playground area,
Yeah,
that somehow that defined that the park area was the, you remember that whole
Right.
conversation?
yeah,
But that didn't make any sense because the whole plot, and in fact, if you read what was submitted, that contradicts what was actually in what was submitted.
yeah. So when the city applied for that funding, I think it was 2006, when they received the money, they dedicated that land on the north side of the street as parkland because they got state money to build a
Right,
playground.
that was the case of,
And the city's response last year was, well, we never made a declaration for the south side of the street, but the grant application to the state acknowledges that the south side of the street has always been a ball field. And when you look at the plan that was submitted, it included putting money into the south side of the street.
For me, where the rubber meets the road is the therefore in your resolution. And there's two things basically kind of being asked for.
Yeah,
One is to make that dedication, which is a bit symbolic, or just like, yeah, I don't know that it's doing that much. To make the statement is just,
yeah,
it already is parkland, we all think it's parkland, but we could do it. But the real meat is the next one,
Yeah.
where not only does it, I think maybe what you're implying, Claire, by going to DD Bear is to then pursue it through the right channels to not be parkland or to be undone. But what is being asked of this resolution is to not allow that, because this was done this way, and that's maybe where we need the most legal advice,
yes,
that we can actually void the contract.
right.
So
Right.
that's the biggest item.
So I think it's really, it really is a question for the city attorney and the Crown Council attorney to have this discussion, which I've been trying to arrange actually for a while. But I think that's where the next step is. I mean, it is conceivable that they would now decide, well, in order to fix the situation, now we need to go to the state and and go through the process that you outlined.
Yeah.
I think maybe it was even 2 years ago. That they needed to go through these steps with the state. It's conceivable that that's what they may decide to do.
That makes sense. There's like further questions that I would ask are, how granular do the questions and determinations of parkland get? Like if the south side has been considered a ball field, is that so specific that it's not considered state park area or parkland? And because most of our ballparks in the area are privately owned, like, does it get that granular when there's somebody that is looking to make use of the land in a certain way?
I don't think that it does because the deed itself just says parkland. It doesn't say ball field, it doesn't say
And then the agreement with the school district says,
recreation.
That it can
That's
only,
what you said.
can only be used for, I think it was.
park and recreation purposes.
but that's where like it gets weird because if it doesn't say parkland and it says recreation, then they can make that argument. So that's where my mind, I would like to ask them.
Yeah, no, I think the next step, what I suggest is that we have this, bring this for discussion to the full council, and then, that we get input from our attorney.
Both.
Yes. So that we see what the next.
But I followed the parkland. Would you mind talking a little bit on the idea of avoiding the contract because of this?
Yeah,
And this Glen
You're talking about
Cove versus
the second last,
the last, or I guess
No,
not
the
the
second
last, the second one.
yes. So it's one resolution, but there are two impacts. The first one you named is officially dedicating the site as parkland, and I take your point that it's symbolic because we all agree with this body of evidence, but for my position, it's more than symbolic because when I presented this over a year ago, no one believed me, right? So
Some of us don't.
the body didn't believe me, nothing happened. So I wouldn't shy away from that or discount that because it is meaningful for
The
there to
other
be
one
an
has
official
more meat.
declaration. Yes, but the second resolution seeks to void the contract. Gladsky v. Glen Cove.
Not the second resolution, but
The second,
the second piece further
Yeah.
what's on.
yeah, the second, therefore be it resolved in this resolution. It cites Gladsky v. City of Glen Cove. That's a case where Glen Cove was seeking to sell waterfront property and the contract didn't contemplate that state legislative approval was even necessary. And the court, under those conditions, found that that contract itself was void. So that's the same situation that we have here. The contract that was drawn up in January and May of 2023. At that time, the city, which was rushing to sell this property, didn't know that there was a deed restriction. It should have known that the public treated it as parkland, but it hadn't done a title search. And you look at that contract from May of 23, there's no description of the property. There's a description of State Street, there's a deed, but no one had done a title search. So the deed was uncovered when the developer did their own title search. And the contract, of course, then didn't know that it needed state approval. So that's the holding of that case. And
So that was in the contract, it was that the developer had to do a deed search, and if there was any issue, they were to bring it to the city. Otherwise, it would be assumed that there was no deed, correct? That was a 60-day search in the contract?
yeah. And then
And you have a copy of that?
of the Glen Cove contract or the
No,
Hudson contract?
of the deed that was uncovered during the process.
Oh, yeah, it's in the county records.
Yeah.
Yeah,
So I think that's really important.
yeah, the developer found the deed.
Mhm.
Under the contract with Hudson, if there were defects, then the city could
Correct.
choose to cure them or not.
Right.
I think the city in response tried to get the school,
That is exactly what it is.
right,
Uh-huh.
to release the reverter,
Yeah, but
which
that
is only
doesn't,
part,
it doesn't actually happen until closing. Like they didn't go through a process where they were gonna remove that restriction and it's off the deed now. Like it's still on the deed.
it still is
today.
the deed, yeah.
And if it were to be cured, it's being cured at closing.
Yes,
I believe the school has stopped, they were engaged in some activity relating to this, and they stopped pending the outcome of the current litigation.
I don't know.
I don't know if that's in.
I guess where
Kia would have the facts.
I'm stuck on this a little bit. in
Yeah,
that
sure.
Glenn, the courts nullified
Yes,
the contract between Glen Cove and Gladsky.
yeah.
And we're asking the council to void the contract, in a way following that case law.
Yeah, in effect, doing what the court would force the city to do
I see your point.
if someone litigated it to them.
We're taking a bold step that
Mhm.
really may happen through the Article 78.
Yeah, it's true.
It's not a request of the court in that case.
It isn't.
No.
You didn't mention the parkland issue is not.
Oh, the parkland issue is, yeah, we're looking for a dedication, a declaration of parkland, a finding from the court that based on this body of evidence, the site is parkland and it was not alienated properly.
But if that court were to follow Gladsky versus Glen Cove, they could come to the same, they could do the same as the previous court.
I suppose they could. I don't think we haven't asked them to void the contract on that basis. And again, I think what we've all learned from the last 2 months is that Common Council controls the contract, controls the sale of real estate. And it got into this position because it sold real estate without knowing the nature of the real estate it was selling. The contract doesn't account for that. And it was, yeah, there are several versions of the contract that the council never really
The second one we never, the one that
fully
was signed,
reviewed
the
or.
one that was signed, the council never saw.
I brought that up
But
And it's
yeah,
not the same document.
Right.
Substantively.
Do we as a committee want to have an opinion on that, or do we just want to take it to the council and describe it?
I would like to hear what Mr. Dow has to say, and I'd also like the opinion of
And,
Andy Howard, yeah.
yeah, I would like to get advice before saying, I mean, at face value, I agree with this. I hear your thing about the council declaring the contract void. Is that something, is that an action we should be taking? And that's where I think we need to get legal advice.
Because I'm not saying personally that, I mean, I think I'd like to
Yes,
personally, but
I would too.
whether we should, is
I would too,
what I'm saying.
yeah. Any other comments from the committee? So we'll send this to the full council, and this time I will not ignore it on the agenda.
No, but per that, do we need to wait for the legal advice? Should we get that legal advice before we bring it to the council? They're gonna
Is he
be,
going to be
they're gonna
back?
do the same.
I only heard today that he was out of town. So,
But you know what I mean? Like, if we don't have their opinion.
yeah, no, I agree with you. I think that we need to have a attorney-client session, right?
Mhm.
So what I can do is connect with Andy and with Ken and see when he's going to be back. And maybe at the formal meeting that we will bring this. I think probably Monday is too soon, because I don't know, Ken will probably be back at the end of this week, but I really have no idea when he's going back. Because all I know is that he's not here tonight. So, but I think that's what we do. Any other comments from the committee? Okay.
Yeah.
Public?
If I may just, I'm just curious how you would take it, I did title searching. I did it for 10 years in New Jersey, in 2008. But anyway, I don't know how you go back to a deed and you take a clause, what they call the word, what's the word, very,
A deed restriction.
a deed restriction, where I don't know how you undo that historically. I don't know that a new
Yeah.
school or a new
Does the school even have the
council
right?
can actually go ahead and take a historic document that was memorialized, put in place. I don't know how you undo that. I mean, the Dunn Warehouse has a fence requirement. You know, it's just another example of like historic deed.
Good point.
So I did just want to say on the parkland resolution, it's mostly whereas laying out the record and the history of the property. The two requests are to declare it officially. The second request is to terminate the contract on that basis. I'll give you the case. I haven't read it in a month, so I'm sorry I've done more details, but it is directly on point. I'll make sure Mr. Dow sees it as well. And if the council is willing to move on that first request of an official declaration,
Yeah.
then there's nothing
I
stopping.
don't see any issue with that myself. I have a question about Glen Cove though. So the Glen Cove case that you're describing, it was waterfront property, right?
Yeah.
So aren't there different rules about waterfront versus parkland?
They sort of merge. There's this General City Law 20, Section 4, or something like that, refers to waterfront and park property, and it all is kind of in the same level of protected status. And then the doctrine of parkland alienation is mostly through court decisions, but they sort of reach the same place, that only the state legislature can authorize the sale of one or the other.
Okay, yeah. All right, so let's go to the other one that you sent us. So this is the parkland. So the other one relates to declare Carney Realty and Rockland Group in default. So, walk us through this.
Yeah, so I'd like to just, I think the last 2 months we've all learned a lot about whose authority is whose in the city government by the discovery of this contract extension. So my research, my position on this is that the extension that was signed by the mayor that wasn't approved by Common Council, it's a material change to the contract. Contract had a closing date which is passed. The mayor's extension wasn't approved by Common Council, and based on the resolution that council passed last month, you can find it, but it reasserted its authority to review any substantive changes to real estate contracts. So that begs the question of what does this extension do if it was a substantive change that wasn't reviewed or approved by council? And in my opinion, it's just a piece of paper right now. It's unenforceable. It doesn't mean anything because it wasn't approved by council. So if that's the case, then May 3rd is still the deadline. We're long past May 3rd. That puts Kearney in a technical default because it hasn't closed on the Mill Street property, but more importantly, they never pursued State Street, and they never pursued Rossman Avenue. I think Rossman Avenue was...
That one was cancelled.
Right, but they never... The whole spirit of selecting Kearney as the developer was under this scattered site housing development
That is what we're told, yeah.
plan. And the legislative authorization to sell any city property to Kearney is conditioned on development of all 3 sites. And then the contracts are drawn up so that the sites are bound together based on that plan.
Except that there were 2 contracts,
Right,
one for Rossman and one for Mill and State.
right. So Mill and State are bound in
They
contract.
are bound in the same contract. The Rossman one, I don't have any documentation on this, but what was explained to us at that time, you remember this, was that the lots, the 2 lots that they had, there was an issue with the size of the lots and what they were planning to do.
Yeah.
Because they were going to have this was a rent-to-own type situation, and the homeowners were going to have a secondary unit, which would be a rental unit, and that would be an assist in covering costs of mortgage and all of this. That was the whole structure of the thing. And there were issues with, I believe it was the size of the lot when they went to the state related to funding for that project.
All I remembered about that was that there was some kind of technical hitch,
Yeah.
and then it fell
And
apart.
that contract went away. Why Rossman was handled in a separate contract, I do not know.
Yeah,
When we were looking through trying to find all the documents relating to this, I expected to find either one contract for all 3 or 3 contracts. And I didn't expect to find one for Mill and State and a separate one for Rossman, but that's what we got.
so
Yeah,
we have a contract that binds Mill and State, and the legislative authorization for all of them requires development of all 3. So the failure to even pursue State Street or
That to
pursue
me-
Rossman
That
is
to me is the more compelling argument. With regard to the date, what I have been told, again, we would have to get legal advice on this, is that when you have a on or before language with a date, that there needs to be additional language saying time being of the essence or something like that, that to make that date truly a final date.
to make it straight.
But if it's on or before and it's not specified that this is a time limitation, that on or before can be interpreted more broadly. Which would mean,
Which is,
like, putting to one side a minute, whether or not we got to review and approve the amendment. In that scenario, that amendment would be okay because that on or before is fuzzy language. It seems to be straightforward, clear English to me, but
Yeah.
in the law apparently it's not. That's what I've been told. So the amendment, if it had gone through a different process, there might not be any question about it. So, that to me is, that's still fuzzy to me, and I think we need legal advice on that. But the fact that nothing was done with State Street, and as you lay out here, that they didn't pursue funding for it, like all of those things are in the contract, that they are to make due diligent effort to get funding and so forth.
Yes.
And that if they fail to do so, that then the contract is null and void.
So if nothing else, we'll end up with a tied up empty lot in State Street. That could be a scenario here. Regardless, the real physical result of this could be just State Street is owned by Kearney and the city can do nothing with it.
Yeah, that's correct.
It never
But
gets
they
done.
got, no money's exchanged hands.
No, nothing was
So-
closed. Nothing was closed.
Yeah.
But I'm trying to turn off my hearing aids here.
One question I asked you, Jack, and I wonder if you had time to think about it, was the reason May 3rd didn't work is because of the Article 78.
Mhm.
And that, I guess, that feels wrong in a way, that annulling the contract in your interest and your neighbor's interest, yet at the same time, your Article 78 is the one that caused it to go beyond the May 3rd date. And I'm not personally, again, offended by it, because I do want to try to get out of this, but it feels like a legal loophole. Like a tactic to force the contract to not be closable past May 3rd by violating Article 78 that forces it to go beyond May 3rd.
Yeah, I take your point. The Article 78, there is no judicial order, there's no restraining order, preliminary injunction, there's no automatic stay. I hate to say this out loud, but technically the city could sell Mill Street right now. That would be an outrageous thing to do, but it could. And then if the development were built based on the preliminary site plan, the lawsuit would face the problem of being moot, right? Because the building had already been built. That's an extreme course of events. I think the city is in a position of effectively cross defaults. The city can't sell Mill Street because the plan that was put forward and rubber stamped is inadequate for that site and is justifiably being challenged in court. But meanwhile, the developer who promised to build 2 other sites has made no effort to build either of the sites.
That to use
Yeah.
Or provided any explanation or update or anything.
Because I do think, I wonder if the scenario is any different if this extension had been signed before May 3rd instead of May 20th. I think
Yeah.
maybe a
Well, I
technicality,
think
but
there's still, no matter when it's signed, the issue with their failure to do anything to move forward on State Street is an issue.
yes, I agree.
And I agree with Margaret, your point about the timing. The difference between May 3rd and extension on May 20th is justify, honor before. That gives some grace period. I think the mayor's extension is unenforceable. That's a side issue. For other reasons, yeah. Not for being late, but for not being approved by council.
Yeah, that's a good way to put it.
So this one again, I think both of these, what we need, I'm going to come to you. Both of these, I think what we need to do is have an attorney-client session, have city attorney and common council attorney look at this and give us some advice. Do you have any comments on this one?
No, I'm processing and I'm also like, projects aside, I'm also stuck on the clause from the school district when they sold the land and how, our opinion and doing something separate than what is in that sale could also put us in a wild situation, because it's different than what that contract, that sale with the school district says. So I think that's something that we also need to keep in the front of our mind, because that's set up for more legal action on top of what's already been.
Could you say that again in another way?
Maybe.
He's very eloquent.
The terms of the sale or the, saying that you couldn't use the city, it would forego unless they use the land for parkland and recreational.
That one is, the city.
Give me the right word.
yeah, this, basically they deeded it to the city with the
Right.
condition that.
with the condition.
Right.
And if the city now declares that to be official parkland, where it didn't already have that designation, that makes me nervous that that would open us up to, like, the council aggressively intervening with blocking the project from happening, and that would open us up to further litigation on top of what's already being litigated. Does that make sense?
I understand.
Yeah,
So to just the point that Jason brought up about the Article 78, and just to be totally transparent, I'm not in favor of the Mill Street project. So I'm, just want that to be clearly understood in my position. But in terms of the Article 78, that the argument that Jason brought up about how it could be unfair, because it's a tactic and whatever, that's making the assumption that the Article 78 is the only compelling argument that stopped them from closing. There are a number, so, and you don't actually know that the Article 78 really had that impact and isn't just part of a whole mishmash of other unresolved issues. So I think the whole picture, speaks towards this project, and I'm not a supporter of the project,
Right.
not going through.
are there any hands raised online?
No.
Okay, anything else for us tonight?
No, I don't think so. I guess
Thank
the
you very
last thing I want to say is that when we got that rain, the other day, our street flooded, the intersection was impassable, the road was closed for most of the day.
I was gonna say, how long did the flood?
Most of the day, I mean, you could ask DPW to know exactly when they closed and opened it, but I can tell you that from my neighbor's, door camera, the flash of the flash cutting was 15 minutes. It went from rain going this direction to flood coming this direction that overflowed into her front doorstep in 15 minutes.
Yeah.
And I mean, it was in the hour of 6:30, so it's at the time when people will be leaving their house to go to work, but, it's not a surprise. I don't support this project. I think there's a number of reasons, to Lloyd's point, there's a number of reasons to get out of this project, and I'm presenting you with a few, and there are a few others, and there's a few beyond that, like the payment to the school never being authorized, which I think is something the council needs to understand.
That's correct. You know about that?
Yes.
One last point, if I may. I think you can go ahead with the motion to declare it as parkland, and I think that's an action that can be taken today, whether it's
No, it's not.
No, it
or referred to the board and recommended.
We will seek legal counsel
There.
and proceed accordingly.
I think that's a
Thank
good
you
move.
so much.
Thank you. Thanks for having me.
Alrighty, so, next we have 3, amendments to code that we got from, Nick Fox, our new, code enforcement officer. I'm sorry, but can we not have a conversation? We can begin with 93, which is building permits.
Okay.
we have Ken here for this?
Excuse me?
Shouldn't we have Ken here for this?
We're reviewing it. It's going to go to the full council. We're just looking at this to see if anyone has anything they question.
I do.
Yeah, no, and that's why we're having a conversation.
But it would be great to have a lawyer here to answer the questions. Just like,
I don't dispute that, but here we are.
okay.
Okay, so the demolition thing, what he wanted to do here,
She's looking at 97.
97.
What, 97 or 93?
I'm sorry, hang on a second, I've got the wrong document. I'm sorry, it's supposed to be 93. 93.
Oh, we have to go to the amendment.
The one that goes with, what's the name of the document that goes with the 93 code?
There's 2, there's the city code, building permits, and then there's the amendment.
Right, but what's the electronic name of the amendment to 93?
Building permits, chapter. 93.
Excuse me?
Building permits, CH 93.
That's the current.
City Code Chapter 93 amendment.
That's what I'm looking for, hang on.
Where's that? In your document, it's not in the email.
No.
Okay.
Okay. It's a little different.
So I'm gonna have to go on.
I thought that was-
Okay. City Code Chapter 93 amendment. So what this is about is for large projects to have an additional language. He's just adding language to the current Chapter 93 to allow for having a third-party reviewer for complex projects who would be, the payment would be by the applicant, as an escrow, but it addresses the fact that we have a very small code enforcement building inspector department, and something like, pocketbook or the hotel that's being built on Marne and Fort and so on.
This is what he was talking about in safety communicator?
Yes, exactly. So this is a situation where we're adding language that allows for the use of a third party which would be selected by the code enforcement officer. I think it's very important that it not be something that the developer gets to select, but it has to be somebody that our code enforcement officer engages as a consultant.
I think this is great, except that I would love to have,
We understand that. We got the message.
okay.
I have some experience with this, and special inspectors are often hired by the applicant, and they write a report that gets sent to the code enforcement. So, for example, be a specific trade, like the electrical. So instead of needing it to even go through the city and us to collect, kind of like the way the planning board collects escrow, it's on the applicant to hire their own plumbing, electrical, whatever trade you want to designate. They hire that engineering company, so to speak, writes, they write a report.
Yeah, I'm not comfortable with that in that I don't, because the client in that situation is the developer, and I question the independence. I understand
There is a field.
I understand that there are ethical standards of independence. I get that, but at the end of the day, the client is the developer, and the report is for the client. And I would really prefer to see an independent assessment. It's still, you could still do the same thing you're talking about, and that would be the applicant's thing, but it has to be a company or an inspector that the code department chooses, not the developer chooses. But I think that client relationship is very important. Now, I've written enough reports for clients that are, independent, and it's a very difficult thing to maintain true independence when
The money's coming from.
you're being paid by the person for whom you are doing a independent review.
Yeah.
It's a very difficult thing.
Yeah. I think it makes, well, Nick's in charge of this, so he can do as much work as he wants. But I've seen it more specific trades. But
No, I get what you're saying.
I don't know that I would want to see a general overall like Nick, be replaced by a company that inspects the entire property.
Okay.
Like trade by trade, but not the general overall building.
So, in terms of,
But I haven't talked to Nick about that.
yeah.
I don't know if this would eliminate, if he could still do that.
I think that what you're talking about could be accomplished here if this were made more specific. Because at the moment, it's kind of like, it's fairly general that the third-party reviewer, it doesn't say for a focused review.
Yeah.
Which I think is what you're getting at.
Or if he does intend it to be the entire project, then maybe that, at least say that's what he intends.
Okay.
That would be pretty difficult.
Yeah, I don't know companies that do that. I know, there are no companies that do trade-specific special inspections.
So, again, this is one where, I think what we want to say to the full council is, these are some of the questions that we have here. Should this be trade specific? Are we talking about?
Does it need to go to full council yet? Should it go back to safety to ask
That's what I was
for more
thinking.
clarification?
Yeah, maybe.
Is there
maybe
anything
that's a good idea.
really legal about this? It's
No.
just,
Yeah, I think
I
that's
think you
a good
should
idea.
go back to the safety committee and ask Nick to break it down and explain to us, like, what else is in the field, like, what are you basing this on? Have you seen other entities that do this large of a scale of an inspection, or are you specifically asking for these focal areas to be taken off of the code enforcement's desk?
Why don't you?
In these large scale projects?
Only, he only wants to do large
Yes.
scale. Okay, so I think that's a good idea. We'll send, this one, let me write this down. This one is, I have to get my numbers.
So refer it back to safety.
Let me get the numbers up.
Review and inspection is 93.
93 goes back to safety, and that's the third party. Yes,
So actually, I find this quite interesting because while I'm not in favor of a city manager, it seems like we need some city-centric point of view, or city's, input onto whether, this fits actually in and it works within the overall city. Because there are many projects. So it's kind of interesting in the term, I'm not really in favor of a city manager, but I would think that the city manager would oversee and see if this further development fit within, and that could actually work.
We
That's
need
the
a city
problem.
planner.
That's what I mean.
can we stay on topic?
I don't think so. I think that this makes a lot of sense for him seeing what his department can handle, and I think if he just spells out exactly what he's looking for, it doesn't need another layer of
Okay, so
breaking it down.
I hear what you're saying. I'm just anticipating that
Yeah,
a bigger.
I hope something much bigger than what these large projects are, they don't fit.
That's the question. Do they or don't they?
But I think this body is like, this is what this process is for. I think it's doing.
So the vacant building, this is number 91. Let's see. So in my discussion with Nick on this one of the concerns that he had, which he talked about at safety, was that the order in which, the way this is currently written, there are three choices for the property. And the first choice that's listed is demolition. And so this is really more a question of reordering the priorities. The demolition should not be the first thought. So that I don't think that, as I read this, I'm not seeing it as changing the options that an owner has, but more a question of establishing what is the hierarchy here, and that demolition should be what you're looking at as a last resort, and that other options should be looked at first. That's how I read this. So,
There's also a big emphasis on plan, whatever the owner's going to do,
Mhm,
that they inform the city
mhm,
code enforcement
yes.
what that plan is.
I guess my only question there would be then like, you know, if, for example, a landlord doesn't have a long specific plan, it's not gonna turn into something large, like what is the approval process of like, what's a good enough plan?
I think they just want something like, okay, because thus and such, you know, multiple joists are rotten and the place is falling down essentially. We can't rehab it, we can never rehab it. We should just take it out and you give them the plan and what they're doing for that moment. And maybe, I don't know,
But
I
the
guess that's
plan,
it.
he wants the plan to include
Yeah.
like flatten it,
Yeah,
plan to
exactly.
make it,
Plan
make it not a blight.
But the
But what I'm saying is,
you wanna
if they don't have that kind of plan, or if they're not looking to demolish, but they don't have that much of a plan, what's the step in between them not being able to present a plan and having the vacant building? Like, what is the course of action that code enforcement would take?
Well,
He shows fines.
we do have there are in the fee schedule, that's why the 365 days comes from.
Yep.
You cannot have, we haven't been enforcing it, but you are not supposed to have a building that is vacant for, you have to pay a fee if you're going to have a vacant building.
But there's something in there that is really strange to me. It says something about a door, the doors being locked in the proper way, or.
Yes, that's correct.
But what if the door's locked and everything's fine with that, but it's sat vacant for 7 years?
There are fines associated with that, which we have not enforced. It's not in here, it's in
Okay.
the fee schedule.
But I think he's got a way to prove a building is vacant. I don't know if that's defined well enough in here, but he's mentioned, either it's been reported by neighbors
Right.
or just people know it's vacant.
Right, but if 91.3A addresses, an owner shall register with code enforcement not later than 30 days after any building in the city becomes a vacant building, or not later than 30 days after being notified by code of the requirement to register. So that, he is just changing the language in that section where the order of what you should be doing, in his mind, was kind of backwards, because demolition should not be the first option that you're thinking about.
But it also starts with a letter from him saying, I think your building's vacant.
Oh, well, that's
You-
already.
You could respond saying it's not vacant.
Yeah,
and
but
we prove
that's,
it to you.
right, and that's, everything above 91.3A is unchanged. That's where the registration process, and registration shall be submitted on forms provided by code enforcement. And the information you have to provide. And then it goes into section C where it has these 3 choices where he wants to change the order in which those choices are being considered. So I think, this one I think is probably ready to go to the full council. Or I don't think this needs to direct decision.
No, I don't. The only legal question I had was about whether those fines, and I think you mentioned that whether those fines were considered tax or whether.
I mean, if what I was proposing, Ken had a problem with it being, if we did payment in lieu of parking, we changed the code so that there are requirements about parking for development. And then we had not a fine, not a tax, but we had a suggestion of, here's an alternative to building things. He still considered that a tax. So why wouldn't he consider this a tax? I don't know.
Or instead of them being fines, should they be liens?
Oh, okay, that's another thing.
Because that gives you a lot of strength.
Yeah.
I think that's the only place that I had any legal advice wanted.
So that's-
regarding those increasing
We do have to
fees.
get Ken to review all of this. But I don't think we need to send this one back to
No, I agree with that.
Okay.
Sarah.
When let me speak on this?
Sure.
So I foiled the city on the vacant housing registry somewhere around the beginning of the year. And I got a response, surprisingly enough, that they had no records of any vacant properties. So that was kind of interesting. And coincidentally, there is another initiative that the county is embarking upon with Chris Brown and Patterns for Progress, where they're identifying county-wide properties that have, I guess, 3 different classifications of disheveled or, needing love properties and vacant and different levels. We don't have all the particulars, but there is a county-wide effort that's been initiated, and you may want to liaise with that. That's all I have to say.
I think this would be very helpful, and I think Nick is making a good effort to get the balls started on collecting that vacant list that is missing.
Yes. And there is actually a list of vacant properties.
I'll foil it
So
again.
I don't know what you got back in your file, but I know that there is a list. And it has been discussed in council.
91-2 is what I was talking about.
Oh, I just wrote it.
Oh, sorry. Oh, well, I'll just read it to you. It's very easy.
But he's not amending that.
No, I know, but he should, is what I'm saying. Is a building or a portion of the building which is unoccupied, unsecured, unoccupied, secured by other than normal means, unoccupied, unsafe, unoccupied, has multiple housing or building code violations, illegally occupied. So nowhere here does it say that it's unoccupied yet secured.
I went through that with him when he was working on this, and
Why is that?
no, let me read it because I was focused on the amendment.
Okay.
And he explained why that is the way it is. Hang on.
Because there are
Just a moment.
buildings that are secure.
So, there are definitions of unoccupied and unsecured. And a vacant building is any of the following combinations. It's unoccupied and unsecured. It's unoccupied and secured by something than normal means.
This is what I just read you.
Yes, I know.
But why not secured? Unoccupied and secured.
That I believe does not require registration.
Why?
So,
That's what I'm asking.
I know an example of that as well. 111 Green Street was purchased by a corporation 2 years ago.
And it's sitting
And
empty
they
and with a
never-
lock on the door.
It looks like a regular house, unless you guys know what it is.
I can explain the answer to that.
And the one that I talked to you about is falling apart, but it's
Okay.
secure.
So, I own a property. I am maintaining it. It is secured in an appropriate fashion. I am not living in it. It's an investment. Maybe I'm going to sell it for years. I think that the property prices are going up. I think I'm going to sell this a couple of years from now. Whatever. I actually have rights as a property owner to do that. You cannot force me to use my property. That's why unoccupied and secured.
But-
you asked.
I know, but I'm going to say something that is very valid, and the longer a property sits without someone living in it, the more likely it is to completely disintegrate and fall apart.
That's fine, but I'm explaining to you the logic as to why
Okay, so,
that is not included in this category, because you cannot compel somebody.
but could there be a time period?
I don't think you can compel people to do that.
I'd like to, because that,
Me too.
it hurts neighborhoods.
It does.
I'm
But
not-
doesn't that fit into what we were just asking about the other, like, that's the plan, right? It's similar where if you set the
No,
timeline.
you see, this is not, the issue here is that, a building that is unoccupied and secured in a normal fashion is not considered a vacant building. It's not registered. You can own a property and have it sit empty,
That's the
so
problem.
long as
It is a problem.
so long as you secure it. Right, so it's
It's a
not
huge
falling
problem.
down, you're paying your taxes, there's no code violation going on with this property, it's all fine. It's just that you're
But I
not,
think as a city, I would say like the timeline matters because
okay,
you
but,
may own the property, but what is it doing?
so that's, we can bring that up for advice from, legal,
Which is
but,
what she's asking.
right, no, we can get advice on that, but what I was answering was the rationale for why that is not considered a vacant property.
The
Because
property
I-
owner's rights, okay, I get it, but you're actually doing something that, like Jason says, destroys the neighborhood. Also, makes a real problem for
I don't
people.
disagree with you, but I also think that there's a, and that, when I asked him the very same question, do I think it is a good thing or a moral thing to do to have a property and have it sit vacant when people that don't have homes? No, I don't.
Well, I think that's our role as council members, right? Is to give the legal advice if we as council members and representing our constituents think that in the character of this city, it's something that we need to do something about, then
So we
we should figure out how to do something
can
about
bring
it.
that up as, what legally, what can we do in the city of New York with regard to property that is maintained, no code violations,
I think that's
property
what we're
secured.
asking.
We can do that, and that was
And most of
exactly,
these are not maintained.
that's exactly the
Maybe this
conversation I had with him when we first
No,
started.
it has a code violation because the retaining wall at the front is falling over the
Okay.
sidewalk. So
Okay.
the house itself looks fine, but their retaining wall is falling over, so they do have a code violation.
So, but with regard to, the amendment that, the one that he is proposing, which is changing, the order, do we have any problems? Like,
No
yes, there's other
problems.
stuff we think should be done, but on that, so this we can send forward.
Yep.
But we might also then ask, what can we do about the vacant?
Vacant and secure.
Unoccupied and secure.
Yeah.
Okay, what authority do we have? Okay, hang on.
I'm taking notes, can we?
Sorry?
So while you take your notes, can we give us comments?
I have a comment.
Yeah, I'd like to be able to listen to him.
Yeah. I'm gonna concentrate.
Okay, go ahead.
It seems to me what we're doing is creating another classification of property that we're looking at handling in another way. I don't know what you would call it. Unproductive property or something like it, or non-contributing. And I think this is largely what we experienced with Galvin and a lot of the complaints about Galvin.
Exactly.
So,
I was just thought of another one that's number 12 Park Place, just down from Grove Street. It's a
Right.
building that's been sitting for years, theoretically for sale, but just empty.
is that the firehouse?
Next to the firehouse, the next one.
Yeah, but the fire-
Between the firehouse and
I think the firehouse is in
In
the
the-
contract.
the hotel.
Okay, so one more?
Next is 97. Trying to find that one. This is demo. Chapter 97 is demo codes, and he wants to, let me see what he wanted to do on that one. Amendment to demo. So in this one, when he was going through this, the current language, if there's no party wall, puts the onus on the property owner whose building is not being demolished. So I'm demolishing a building, my next door neighbor's property, it's his problem to figure out the security of his building that might result from that demolition, which makes no sense.
That's ridiculous.
So this is to change that scenario. The other thing that in the current code does not speak to the condition that a site must be left in if you are demolishing a building and not building anything on top. So this is where we have situations in different parts of the city where something is demolished and the lot is left like it's basically a pit and nothing is done with it. So what he was trying to accomplish here was to put it on the person doing the demolition to be responsible for the safety of the buildings that might be impacted. And so that's why it says, in all cases involving demolition of a building or structure, it shall be the responsibility of the property owner and/or contractor. The previous language specifically said that if there was no party wall, it was the responsibility of the person who had the house next door, which is crazy, right? And the other addition that he wanted was relating to the site itself. To add language that would be backfilled, drainage, no exposed foundations, so that you do not have basically a blighted property. So I think I didn't have any issues with any of this.
I don't either, except that I can, in my mind, envision a couple of places where there's only 2 walls left of the original foundation, and they are actually acting as retaining walls for other properties, and then there's nothing on another side. So in that case, I mean, what do you backfill it so that it's a hill? I don't know.
I can't answer that.
Do you know what I mean?
Well, I'm picturing the one at 7th and State, and that has that situation.
Yeah.
But I think in that case, Nick would see that as being backfilled, fence taken down, and then what is retaining would actually be underground now.
Yes. But
So-
it would then become an incline. It wouldn't be a
No,
box.
that would make it flat in that case. It's a pit right now. Fill in the pit, is what he's saying, and then the fences could come down.
That's part of what he's trying to address here. Is if
No, I get it,
Yeah.
but I'm just worried that people are gonna look at language and go, well,
Well, theoretically, if you demo that retaining wall, you're gonna damage the neighbor's property. which
Exactly,
shows
that's
as
what I'm
your
saying,
responsibility. So you have to have a good plan for your demo, still. I don't think this precludes that.
So can we take this one to the full
yeah,
council?
absolutely,
Okay,
this
so
one's fine.
97, 74, Okay, anybody on the line? Good?
So
Any
boring,
other-
even
any
Ronald
other-
left.
Sorry?
It was so boring, even Ronald left.
No, listen, I'm good,
Okay.
thank you.
So can we have a motion to adjourn? Second. Excellent. We are adjourned, and we only
Very
have 8
close to
minutes
an hour.
left.